When it comes to reproductive issues, the state's interest in preserving life and health sometimes conflicts with an individual's interest in controlling their bodies and being free from state interference. As we look at contraception and abortion laws, note how attempts to balance those competing interests drive many reproduction laws. We'll start with procreation and contraception issues. Modern procreation and contraception rights began in 1942. That year, the United States Supreme Court decided Skinner v. Oklahoma. In Skinner, an Oklahoma law required sterilization of prisoners convicted of 2 crimes of moral turpitude. The court recognized that individuals have a fundamental constitutional right under the 14th Amendment to procreate and to marry. A state law may impair these fundamental rights only if it passes strict scrutiny, which is a high bar. Because Oklahoma's law didn't meet that test, it was unconstitutional. In 1965, the court decided Griswold v. Connecticut. In Griswold, a Connecticut law outlawed using contraceptives, even for married people. The court recognized a constitutional right to privacy that protects the fundamental rights created by the 14th Amendment. Because the Connecticut law violated marital privacy rights, it was unconstitutional. In 1972, in Eisenstadt v. Baird, the court addressed a similar Massachusetts law that banned contraceptives but had an exception for married people. The court recognized that both married and unmarried people have a privacy right to decide whether to have children, and therefore to access contraception. Thus, the Massachusetts law was unconstitutional. In addition, courts typically use a similar privacy framework to analyze individual rights regarding medically assisted procreation. For example, a Tennessee court used privacy rights to determine that after a divorce, an ex-husband may prevent an ex-wife from using an embryo frozen during the marriage.